Welcome to Shaping Canada, 150 Years of Landmark Decisions. The Canada we know today wasn't built by chance. Argument by argument, judgment by judgment. It was forged by law within a unique justice system born from the union of the civil law and common law and increasingly indigenous legal traditions. In this series, we mark the Supreme Court of Canada's 150th anniversary by decoding some rulings that defined our rights, our freedoms, and our collective identity. From criminal law to indigenous rights and the division of powers, the decisions we chose to share with you are not just ancient history, they still shape our reality today. I am your host, Hugo Martin, and I ask you to join me for exclusive conversations with the 9 justices of the Supreme Court and leading constitutional experts as we uncover the context, the impact, and the lasting legacy of these judgments. Madam Justice Martin, welcome to Shaping Canada, 150 Years of Landmark Decisions. Your path as a scholar, lawyer, and judge leading to your appointment to the Supreme Court of Canada on December 18, 2017 is inspiring. You were a law professor and dean of the Faculty of Law at the University of Calgary. As a lawyer, you focused on criminal and constitutional cases and worked on very important issues for Canadian society, including the Indian Residential School Settlement Agreement and helping people who were wrongly convicted. Since joining the Supreme Court, your work has had a significant impact. Your legal philosophy centers on a commitment to fairness and equal justice for all, viewing charter rights as evolving with changing social realities. It's still a theme, it's still a motivation for you?
One of the reasons I went to law school was the basic search for equal justice for all, and it is a theme. I would hope it was not just my personal choice of a philosophy, but the very fundamental principles by which all Canadians looked at their legal system. They have to have public confidence in their legal system. They have to see themselves in their legal system, and they have to see themselves fairly represented in the system, and they also have to understand that the decision makers, the judges, have a full appreciation of the context of their lives and how they live their lives and the vulnerabilities that certain people have as opposed to others. And that if we can say anything about Canada, we're bilingual, bijuridical, we're multicultural, we're pluralistic. And a decision maker sitting in a court has to understand the diversity of the people that come before court to render proper justice.
Your approach has produced landmark rulings that address systemic inequalities while maintaining a rigorous legal analysis. Would you say that your voice has been transformative?
What I can say is that over the course of 150 years of Canada's Supreme Court jurisprudence, we do see an ever-widening lens of what's relevant in law, what the narrative of laws should take into account, even a different conception of rights. Perhaps at the beginning, it was a focus on individuals and freedom. Very important rights still today. But what we see with the Charter is that Canadian rights are different. We have language rights. We have group-based rights. We have Indigenous rights that are separately enunciated in our constitutional documents. We have a commitment to equality, which is broadly stated, equality before and under the law, the equal benefit and the equal burden of law. This could not be stated in more generous terms in terms of a legal protection. And what we've seen over the course of the time that we've had the Charter since 1982 is not just that these rights have been compartmentalized and defined and only applied in specific areas. We see how the method of thinking about people and social groups and equality has been pulled through into other areas of law, into evidence, into procedure, into substantive rights, and into all areas of law, changing, for example, how we do spousal support, child support, who we give a legal privilege to in terms of evidence, who gets a marital privilege has changed. We look at and we say our law of self-defense which I've written on, has changed, not just because Parliament has said it's changed, but because the courts have asked, what does it look like for a battered woman who's been in a history of an abusive relationship when she tries to defend herself? Is that a different model than what we would see in a barroom fight between two men who are engaged in fisticuffs? So the law has taken this notion of equality and the different methodology and tried to deliver, I think, over the last 150 years, exactly what people need to have that equal justice. No one person represents a universe of ideas. And anyone who gets to the court has read widely about many, many things. These were the things that I wanted to study, and certain things that I think are important. I worked on judicial education around social context issues, so we were much more attuned to the focus of what a group dimension might have on an individual's position in society, and that judges needed to understand that. I would hope that it's a very widely held view. And what we see, for example, in judicial education across the country is a very strong commitment to understanding the lives of Canadians and transforming the way we teach about law to judges so that they do understand how individuals live and who's appearing in front of them, how certain people may look you in the eyes when they're a witness, and other people, that's not their custom, and that's not how they deal with respect. So if they look away, they're not being evasive, they're being respectful. So it's to understand those kinds of very important things in courtrooms across the country.
You are also known for your expertise in judicial ethics and your efforts to remove stereotypes in the justice system, especially concerning sexual assault. How does your expertise help you in deciding whether a mandatory minimum sentence is sometimes correct and sometimes unconstitutional?
The provision in the Charter about cruel and unusual punishment is quite a particular provision, but it's a very important one because it says it's the outer limit in terms of what society will impose on people for transgressions. These are people who have offended. The presumption of innocence has been rebutted beyond a reasonable doubt. So we're talking about what's the relationship between the goals that we have for sentencing and what the punishment actually produces. Parliament has a very comprehensive set of principles that govern sentencing. Deterrence, denunciation, but rehabilitation as well, safety to society. And so it's a very complicated thing to craft a fit and proportionate sentence. And when the state comes in and says the sentence will be the following, regardless of the situation, it's difficult because what we see and what we understand from being judges is that you can't predict what's going to happen. You don't know the circumstances for everybody. And so perhaps nobody wants people to be using guns, but if a 13-year-old is using a BB gun, is that the same thing? And it is if you have a mandatory minimum. So the court is confronted with what is the mandatory minimum? Parliament is allowed to have mandatory minimums, but the understanding is that that minimum has to take into account the least morally blameworthy person because it applies to everyone. The mandatory minimum will be a minimum for the person who has far exceeded criminality and established a really high level of moral blameworthiness. But what about the people that just barely meet the definition? They meet the definition, they're offenders, but their circumstances are such that that sentence looks like it's too harsh. It's not fit. It's not proportional. And our sentencing regime and our constitutional protections say it has to be fit and proportional. So the Boudreau case, that was a case where there was a mandatory victim surcharge, but it meant that the poorest of the offenders had to keep on coming back to court and faced constant criminal jeopardy because they couldn't afford to pay a surcharge Parliament had imposed. And so the court there very early on said that in Canada, we don't criminalize poverty. and we don't force people who have rehabilitated themselves, who have paid their debts to society, to keep on coming back to court and facing constant legal jeopardy of being re-imprisoned because they can't pay. It's a balancing act there that's sometimes difficult, and sometimes people don't understand it. But the most crucial thing to remember is that you have to look at it through the lens of the offender who is kind of the least morally blameworthy, because that person is swept up in what must be done. Now, if judges have discretion about the sentencing, that person would be sentenced, but perhaps without the mandatory minimum being met in all cases. And that's what we're dealing with there.
I'd like for you to explain, in your view, the role of a dissenting opinion at the Supreme Court.
It's important for everyone to understand that we work as a group, usually as 9. We have strong opinions about the cases and well-developed opinions. And I think that we're very good at speaking with each other and strengthening each other's opinions. So even though a judgment may come out under the pen of one person, we have had a very collective process of commenting and strengthening the decisions. And I know that any decision I've ever written, I think, has been added to and made better by the comments of my colleagues. But sometimes you just don't agree fundamentally with the disposition, or more importantly, you don't agree with the legal reasoning path, because you see if it goes this way, it will have implications for other people, other circumstances which aren't attractive. So in those sorts of cases, you have to be fairly strong that your opinion, your dissenting opinion, is something that is necessary for the development of the law. That's the way that I see it. There is something that needs to be said, because the dissent is a powerful tool. But it also leads to a little less certainty in the law. And sometimes you can see in decisions that judges are writing different paths. And as a former law professor, my students would say to me, what does this case mean? And I would always like us to be able to respond to the Canadian public and the first-year law students and say, this is what it means. So I think about all of that when I'm deciding whether I want to dissent. But then once you've decided that you are really not in agreement, you're kind of obliged to make sure that you put that perspective forward. You're writing against a majority decision because you're passionate about something. And so, yes, you're hoping that because of the way you've written it, the way you've explained it, how social circumstances may change, how governments may look at a decision and say, oh, that was a very good point. Maybe we need to reconsider that when we do any legislative amendment. So there is the hope that there would be some influence and impact, and at least at a minimum that there would be a greater discernment and discussion and debate because there are contrary of views. The Bliss case, the charter and the judges change and say pregnancy-based discrimination is discrimination on the basis of sex. So we do see movement, and we do see the medically assisted dying cases, Rodriguez to Carter. There was a widespread social change. But if you look at the record that was before the court on the Carter case, the trial judge did an extensive review of the Canadian reality. When the Supreme Court looked at the decision in Carter, it had a very full record about what should be considered and how it should be considered.
Madam Justice Martin, as the Supreme Court commemorates its 150th anniversary, throughout your career you have consistently focused on legal education, fighting for equality, and working on Indigenous issues both before and after becoming a judge. From your perspective, how have you seen the Supreme Court's approach to these important and complex societal issues change over time, and what is the court's role in helping Canadians understand these developments?
I think, of course, the most profound development in all of law was in 1982 when we became a constitutional democracy, repatriated our constitution, and have a Charter of Rights. So that brought to the fore the kind of role that the judiciary has. And if you look at the Supreme Court jurisprudence post-Charter, you can see a very conscious effort to grasp what the new role means, how to maintain public confidence in the judicial authority, how to see the separation of powers more clearly. We have spent a lot of time being very conscious about that and dealing with very important issues of our time. The Quebec succession case, for example, is a profound case that showcases on a reference case, not a normal case, but a reference case, about what a nation means and what happens when a province decides that they might like to leave the Federation and succeed. So you had a very careful decision about what are the pillars of our nation. I think it's a conscious grasping of that. In Canada, it's still a crime to propagate hate against an identifiable group. And the court says, why? Well, because we have a multicultural society. And you can't undermine the freedoms and rights of minority groups by using hate speech against them. So it's a grasping there, I think, of tensions and competing principles, and I think a very mature, kind of sincere desire to ensure that that balance is correct. I think the court has also been quite conscious about how we communicate to the Canadian people that we are, in fact, writing for the whole nation. And so there's been steps taken. But if you look at the judgments themselves, oftentimes they're written in less legal ease than they could be. If you look at certain judgments in family law areas, we now understand, for example, that most people in a family law matter are self-represented. Well, if we're making a decision on that, we need to explain it in plain English or French. It has to be more accessible. We're doing many other things in terms of how we communicate directly with the public, but I'm just focusing here on the decisions themselves are organized in a way we often use a writing style that's more clear and communicative.
I see a clear cleavage between pre-1982 and post-1982. The society is now facing other challenges. We're talking about technological challenges, polarization of the society. There's also the immigration issues. How do you see the Supreme Court's role in shaping all these issues?
Well, it's hard to imagine what those issues would be 150 years from now in terms of their detail. But they'll always be about how it is we choose to live with each other and how we choose to live with technology. We may have different technology, but the interests that are protected by privacy, the interests that are protected in terms of the intellectual property, all of these will continue, I think, to be of some significance. The whole evolution from 150 to now and into the next 150 is always the same question of what are the limits to how we will treat each other and what kind of society do we want and what do we insist on from ourselves in terms of what we owe to our neighbors and what we can expect our neighbors to give to us. Those are the same questions. They will present themselves differently as history changes, but my sincere hope for that is that we really maintain that fabulous Canadian value of conversation and allowing a difference of opinion. I mean, the law is a very good vehicle for that. We have a principle in law that you listen to the other side. We understand the pros and cons. People are allowed to argue different positions, and we think that that strengthens the decision that's ultimately taken. And my hope is that that won't change in 150 years.
When we look back 150 years, do you have important cases that shaped Canada and that will, in your view, continue to apply in the future?
Everybody has to say Roncarelli and Duplessis, which was the calling on a premier of a province to account for behavior vis-a-vis a particular person. It's a rule of law case and it's a protection of minority cases, so it's there. We have the succession reference that talks about who we are as a country. We have the Vriend decision in which the Supreme Court recognized that sexual orientation was a protected ground of discrimination under Section 15 of the Charter. Delwyn Vriend was fired from his teaching job because he wasn't protected as a gay man under the Alberta human rights legislation. And what we see in that case is the court understanding that people should be able to take all of themselves to work and into their lives with equal rights. And so the Supreme Court said, we're going to recognize this, but when you look at the Vriend decision, there's such a careful understanding that it's not the courts that are taking this power to define rights away from anyone. With the Charter, Parliament, Canada, citizens of Canada, everybody gave to the courts the obligation to protect rights and to set limits on rights and to set limits on government action. And so the Vriend decision is a spectacular statement of what the court said was modern values, but a way to go forward with the separation of powers.
I'm Justice Martin. Thank you very much for being a part of Shaping Canada, 150 years of landmark decisions.
And thank you for helping Canadians understand how we've shaped for 150 years.
Thank you for joining us for this episode of Shaping Canada, 150 years of landmark decisions. As we've explored today, the law is not static, it is living. Every Supreme Court ruling adds another stone to the foundation of our society. For links to the decisions discussed and more information about our guests, visit shaping-canada.ca and make sure to read the show notes. Subscribe on your favorite podcatcher so you don't miss any part of this series marking the 150th anniversary of the Supreme Court of Canada. Thank you to everyone who contributed to this project: the Supreme Court of Canada, the Right Honourable Richard Wagner, Chief Justice of Canada, the Honourables Nicolas Cazirer, Suzanne Côté, Andromachy Karakatsanis, Sheilah Martin, Malcolm Rowe, Mahmoud Jamal, Michel Obonzawin, and Mary Moreau, Professors Louise Langevin, Jocelyn Downey, Carrie Frock, Naomi Metallic, Karen Drake, Denis Nadeau, Félix Mathieu, Éric Labelle-Eastaff, Marcus Moore, Joel Bakin, Howie Kislowitz, Richard Moon, and François Tanguay-Renaud. Thank you to Maître Michel Lebrun, Miss Sandrine Raymond, Laurence Laperrière, and Laurence Thériault, Mr. Peter Warren, and our producer, Constance Saint-Pierre. This project has been made possible by the Government of Canada. I am Hugo Martin. Until next time.